Good morning, everyone. Thank you very much for coming. We'll have a hearing today. Abortion until birth, the need to pass the Pain-Capable Unborn Child Protection Act. I've introduced legislation with many of my colleagues on this committee on the Republican side. It's called the Pain-Capable Unborn Child Protection Act. It would provide common sense protections for unborn children at 20 weeks after fertilization, a point at which there is significant scientific evidence that abortion inflicts tremendous pain on the unborn child. There are only 7 countries in the world that allow wholesale abortions at the 20-week period. They include China and North Korea. I think Iran, too. The United States should not be in this club. I don't believe abortion 5 months into the pregnancy makes us a better nation. America's at her best when she's standing up for the least among us. We know that an unborn child at the 20th week of pregnancy can feel pain. In fact, anesthesia is administered directly to the unborn child in second trimester fetal surgery. I want to repeat that again. It's standard medical practice to provide anesthesia to a child at the 20-week period because we know they feel pain. So we're providing anesthesia to save the baby's life through an operation. We don't want to do it in a painful way. That's why we provide anesthesia. That says a lot, I think, about the development of the unborn child. This is a new legal theory. Under Roe v. Wade and Planned Parenthood versus Casey, abortions now are allowed until until fetal viability. After that, the state has an interest. What we're saying here is that if medical science tells us that the baby is well developed at 5 months, can feel pain, developed enough to feel excruciating pain, and a procedure to save the baby's life, then we should have restrictions on abortion. You can only imagine the pain that comes from dismemberment. So the point is that legislative bodies like the Congress should have the authority to protect an unborn child from excruciating pain. And that is the theory of the case. And I believe that this is a reasoned approach to a difficult problem. There's probably a reason that only 7 countries in the world allow on-demand abortions at 20 weeks. When you understand what's going on, it's not exactly where you want to go. And I'm trying to have a hearing so that we all understand what's going on. We make an intelligent decision as a nation. Do we want to stay in this club or not? As to me, I do not. And I think that's going to be a widely held view in America when Americans understand what we're trying to do here. The bill focuses on the abortion provider, not the mother. There can be no prosecution of the woman. The penalties will lie against the abortionist. And it is a simple concept. At 5 months, abortion on demand will stop. You will have exceptions for the life of the mother and pregnancies that occurred from rape and incest, commonly held exceptions. So I look forward to this hearing. I look forward to a debate. These are emotional issues, but the country needs to come to grips with the reality of 2019. In 2019, because of the advancement of a medical science, we know that an unborn child in the 5th month of the birthing process can recognize sounds, has 10 fingers and 10 toes, can stretch, can yawn, and can feel pain. And it's up to people in legislative bodies to come to their aid and prevent an excruciating death and have exceptions that make sense. That's what this hearing is all about. With that, I'll turn it over to Senator Feinstein.